Hyman. Well, we're following this breaking story that we've been talking about. Hewlett-Packard suing its former CEO, Mark Hurd, for moving to software company Oracle, where he'll be a president, or at least has been hired as a president. For more perspective, we're joined on the phone from Philadelphia by former federal prosecutor Fred Tecce. Fred has dealt with dozens of trade secrets cases. So, Fred, you know, in this particular case, what would be the grounds for HP suing Mark Hurd?
Well, Julie, the grounds would be twofold. First of all, under just general trade secret law, a trade secret is anything that gives a company competitive advantage that's not known to, obviously, outside of the company. The one I give my students is the 11 herbs and spices that are in Kentucky Fried Chicken. I mean, that's kind of a simple one. But in this instance, HP, I'm sure, has an abundance of information which they think is important, that gives them a competitive advantage, information to which Hurd would have had access, and he can't use it once he leaves. And there's two parts to this. There's actually the law of trade secrets, which applies in basically every state in America, and then there's actually an agreement which Hurd had when he was at HP. And the agreement may provide certain things, but trade secret law is oftentimes broader than these agreements that Hurd had. For instance, looking at the one paragraph to his agreement that I've seen, even though he's got 24 months where he has to engage in certain types of restrictive conduct, that does not give him the right 24 months out to use trade secrets that he got when he was at HP.
Okay, so it's just pretty much he can't use them at all. I mean, there's no real way to enforce this, is there? If he goes to a different company, there's no way to know if he's giving out these trade secrets. So HP presumably would say you can't work there at all.
Correct. Well, if I was HP's counsel, I would be looking for an injunction. I would ask a court to stop him from working there until we can sort this out. And it also depends on kind of what are the nature of the trade secrets to which he had access. For instance, if he was involved in acquisitions when he was at HP, he knows about companies that may be on the block or may be in play as a result of having been at HP. If he gets to Oracle and starts to make a run at that third-party company, that would be a violation of his trade secret agreement or be a violation of trade secret law. So depends on how HP defines its trade secret. For instance, I mean, if his trade secret was the identity of companies that were in play and he wasn't going to do anything like that at Oracle, then arguably he may be able to work around it or outside of it. But based on what I've seen about the guy and what I understand, he was so firmly entrenched at HP that I think he's going to be hard-pressed to show that he's not using confidential information which he had obtained when he was at HP.
You know, Fred, is there any tech company that he could work for under this type of an agreement?
Well, you know, it's interesting, Julie. The answer is yes, there are. I mean, if he ended up going to another tech company doing something completely unrelated to where HP was or within HP's business model and in a capacity that wouldn't draw upon any of the information that he obtained, then the answer is yes. And the further he gets away from that, the better he would be able to do. But it also, it's not just the technology. I mean, I've handled these trade secret cases where companies work for these big employees who work for these big spinal implant companies, and they want to leave and sell something different than spine, but they're calling on the same surgeons, all of which relationships they developed on someone else's dime. So it really plays out on a case-by-case basis.
Right. Okay, Fred, unfortunately we have to leave it there, but again, this breaking story that HP is suing its former CEO, Fred Tecce, attorney there, giving us some perspective. Thanks, Fred.